Good morning and welcome to another of our free bite-sized webinars for charities. This is the first of our webinars focusing specifically on property issues for charities. The topic for today's webinar is an introduction to the restrictions on disposals of charity land in Part 7 of the Charities Act. My colleague Hannah Harbottle will be talking about the key changes to these provisions, which will be coming into force from spring 2023 under the Charities Act 2022. Hannah and I are property lawyers, but we have specific expertise in advising charities. We will be speaking for about 20 minutes today, and we'll have about 10 minutes or so for your questions. There will be a feedback form for you to fill at the end, so please look out for that. If you have any questions as we're speaking, then please do put them in the questions box. There is also a chat box. We have had a few questions from delegates in advance as well. If we can't get to all the questions in today's session, then do feel free to get in touch with Hannah or I. So just to be clear, the new provisions that Hannah is going to talk about from the Charities Act 2022 are not yet in force. The Act has royal assent. This was given in February this year, but it's done in a gradual implementation way, and the changes will not be enforced until probably spring 2023, although we are waiting for the exact programme. Also, just to be clear, we're not talking today about charity trustees' powers to enter into property transactions, and those powers are in their governing documents. And those governing documents vary depending on the legal form of a particular charity. It's always essential to check the governing documents and check those powers, but this session today is about the statutory regime in the Charities Act and not about governing documents, which is a series of webinars in their own right. We're also talking today about non-exempt charities. Part 7 of the Act does not apply to exempt charities. Those charities may well be governed by other provisions in the Charities Act, but not Part 7. And that is usually because those charities are regulated by a different regulator and not the Charity Commission. So, for example, in the case of an education charity, those charities will be governed by the DFE, and the DFE will be the body which needs to give consent to property disposals. So this is Hannah and I. So what we're going to talk to you about today is the general regime on disposals of charity land in the current Act. And we will talk to you about the general prohibition, that is the default position. We'll talk to you about the exceptions to that general prohibition, focusing mainly on the general prohibition, and that's your surveyor's reports, which many of you will be familiar with. We will also talk about the specific prohibition for any disposals to connected parties, which is in section 118 of the Charities Act. I'll then hand over to Hannah, and she will talk about the changes to these provisions in the new Charities Act. And then finally, we will move on to answer some of your questions. So the current regime and the general prohibition or the default position. When we're talking about the default position, I think it's quite useful to understand the historical background to the current law. It's often seen as quite administratively cumbersome and burdensome on charities, but this is actually a reflection of a gradual relaxation in the law over time. The first Charities Act was in 1855. And before that, the position was rather ambiguous, but it was dealt with via various different cases and case law. The position was that subject to anything in a conveyance conveying land to a charity, trustees had power to convey charity property, But the ambiguity was that the transaction was then liable to be set aside unless it could be shown that it was beneficial to the charity. Clearly, this was very unsatisfactory, and I'm sure that it led to a lot of parties not necessarily wanting to contract with charities to acquire their land because of the concern that things could be set aside. So the first one came into effect in 1855, and this made the position a lot clearer. Charity trustees were prevented from disposing of land that formed part of the charity's endowment unless they had the consent of Parliament, the Court, or the Charity Commission. And this was due to concerns about trustees disposing of charity land where this was not in the charity's best interests. So you can see this is where the default position comes from. And this is our fallback position. But nowadays, we have actually had quite a relaxation of this regime, as I hope you will see from what I'm going to explain. It's important to always keep in mind that the aim of this legislation is not to create extra administration and burdens for charities, although some might say it does that. The overriding aim is to ensure that charities can participate in charity property disposals in today's modern world, but that all transactions are done in the best interests of the charity. And I think you can't go too far wrong if you always bear that in mind, that everything must be in the best interests of the charity. I will now move on to explain the exemptions from that general default prohibition. So, the default position will not apply if the disposition is to a person who is not a connected party and the requirements of Section 119 and Section 120 are complied with. So that sounds rather confusing, but it's not as confusing as it looks. Hopefully I can explain. So moving on to the next slide. Oh, slides are a little bit sensitive. So, default position, you may not dispose of a charity property unless you have an order of the court or the Charity Commission. Now, whenever you have a disposal to a connected party, and there is a list there of who those connected parties are, and you'll see that it's extremely broad, it's not possible to rely on the general exemptions, and we will have to go to the Charity Commission. So this is why it's really important to consider at the outset of any land transaction involving a disposal, or in fact an acquisition, but we're not talking about acquisitions specifically today. Very important to ask the question whether the person acquiring the interest is connected in any way to the charity. If they are, that's something we can deal with. We can apply to the Commission and obtain an order. But these orders, as you'll appreciate, take quite some time to be issued, and the Charity Commission has a huge backlog of applications. If you're in any doubt about whether somebody is a connected party, then please ask us and we can look into it for you. Moving on to the next slide. So, assuming we don't have a transaction to a connected party, we then start looking at the general exemption. It's also worth noting that there are some specific exemptions, which I've not listed here on the slides, but in these cases, this would override the connected party issue. So, for example, the one that we come across most often is a transfer of land to another charity for less than the best price, where that transaction is authorised by the transferring properties governing document. That often happens on a charity incorporation or merger. Obviously, the receiving charity is connected, often, assuming the trustees are the same, to the disposing charity. But I'm not going to cover all those specific exemptions today. Again, we always look at whether there is an exemption we can rely on. I'm just going to talk about the general exemption, because this applies in most charity transactions that we deal with. So we also call this the whitewash procedure, which is not to say that it's not important that it's complied with, but it's a process. So the general exemption is contained in sections 119 and 120. The one we're probably most familiar with is the qualified surveyor's report. So whenever you have a disposition, which is for a freehold sale or a lease where it's more than 7 years, you must obtain and consider the advice of a qualified surveyor. You must advertise the disposition as the surveyor advises and recommends, and the trustees must consider that report and then decide that the terms of the disposition are the best that the charity can reasonably obtain. Qualified surveyor essentially is a member of RICS, and the Act goes on to say that it must be somebody who the charity trustees believe have the appropriate experience. Now, the onus here is on the charity trustees to select the best person for the job. So it would be reasonable to ask the surveyor if they have experience of dealing with land transactions of this nature, especially where you've got something like a complicated development sale or overage provisions. You want to know that you've got the right person for the job. Now, these reports can cost quite a lot of money, especially if it is a complicated transaction. But I would say that trustees should remember they will never be criticised for spending money on paying for a really good surveyor's report. What they will be criticised for is not complying with the law. There are various things that have to be covered in that surveyor's report, and I'm not going to go through those. That's really for the surveyor, but those are contained in a separate set of regulations from 1992, and you can look those up online. They cover all the things that the surveyor has to list in that report for it to be a compliant Section 119 qualified surveyor's report. So the other part of the general exemption relates to short leases. So when we say short, we tend to mean that for that to mean leases less than 7 years. That's because the Charities Act draws this distinction. Also worth noting that the Land Registry has that distinction as well, because leases of more than 7 years must be registered at the Land Registry. So short leases, anything less than 7 years. If you've got one of these, obviously, well, depending on circumstances, it's not going to be necessary to get a full qualified surveyor's report. So there is a relaxation here. You can get advice from someone who you reasonably believe can give you advice that that lease is on the best possible terms for the charity. And the advice can be from a surveyor, and in fact, depending on the circumstances, if you wish to obtain a full report because it's, for example, a very high rent or there's something quirky in that lease, then go ahead. If it is a routine sort of commercial lease for investment, then it may be that somebody in the charity is best placed to give that advice if they have the relevant experience. So moving on to the next slide. It's time for me to hand over to Hannah, who will explain the changes to this regime, which are introduced by the new Act, Charities Act 2022.
Thanks, Louisa, that's great. So let's take a look at what's going to change. Most of what Louisa has said we'll just talk about what's going to change and when it's going to come in. As Louisa's already mentioned, in spring 2023, we'll see the changes come in. It's being phased in a staged process. Different parts of the Act, obviously we're just talking about charity land here, but different parts of the Act are coming in a staged process. in the next 12 to 18 months. The charity land regime, which is what we're talking about today, is coming in spring 2023. So the changes originally came about because of a report published in 2017 called Technical Issues in Charity Law, which drew a number of issues and highlighted a number of areas that needed clarification, needed updating, and that were making the process quite difficult for people to follow. As Louisa mentioned, the Act has already received royal assent, and so we now know for sure what's going to come in these changes. So I'll talk about those in a little bit of detail. The benefit of the changes is that it should save time and money for the charity trustees. It should give a wider pool of advisors for people to take advice on disposals, and it should give greater certainty for purchasers of charity land. So as I said, everything that Louisa has covered so far about the basic rules on disposition are still relevant, but there are various changes that we need to talk about. So let's have a quick look at those in detail. So she's spoken about the general restriction contained in 117, which specifies no disposal without the consent of the court or the commission. And I'll talk about an amendment that's been made to that. There's also been a change to the meaning of connected parties and when you will need to obtain consent and when you don't. And there's also been an update to the whitewash procedure, which is the requirement to obtain advice from a qualified surveyor. So let's have a look at the update to the general restriction. So on the left there, you can see the restriction as it was: no land held by or in trust for a charity is to be conveyed, transferred, leased, etc. without consent. And the new Act introduces an amendment to that wording, which specifies that the whole of the land held by the charity, which is the subject matter of the disposal, needs to apply in order for the restriction to catch. So that, in short, means that if you have a charity who is one of multiple beneficiaries of land, if they come to dispose of the whole of that land and the charity only has a partial interest, you don't need to satisfy the rules on disposition and get a qualifying surveyor's report. So some of the examples that are given in the guidance, as I've said, where a charity is one of several beneficial joint tenants or tenants in common, and the entirety of the land is being disposed of, the rules won't catch. Another scenario, if the tenant is one of multiple beneficiaries under a will, and one of those beneficiaries is a charity, and you're disposing of the whole of the charity land, then you don't need to follow the disposition process. It might still be appropriate for the charity to consider taking advice in those circumstances. There's no longer a statutory requirement for them to do so. So that should hopefully make it a little bit easier. It's quite a cumbersome process where only one party is caught by the rules and has to go through the process of getting appropriate advice. It's going to hold up the sale for everybody else. So hopefully that should relieve some of that time and cost burden. Moving on just to look at the second key change that we're talking about today, which is the meaning of connected parties. You can see I've highlighted there employee on the left. So that's the list, the current list of connected parties under the 2011 Act. And the 2022 Act adds a new subclause to A, which specifies that an employee of the charity who's taking a short-term residential tenancy, so an AST or a periodic tenancy of 1 year or less, doesn't fall foul of the connected parties restriction, and so you wouldn't need to obtain Charity Commission consent or an order of the court to make that disposal, as long as the AST or property is being used as their home. You will still need to follow the process for making that disposal if it's caught, but that should make things a little bit easier for charities in particular who have a number of residential properties and who let to members of staff, perhaps in the course of their employment. They don't need to go through the cost and time-consuming process of applying for specific consent for that disposal. So just moving on to the last key point that we talked about is the whitewash procedure and the obligation to obtain a qualifying surveyor's report. So I've put on the screen the text of the original wording and then amended by the changes that are being brought in by the 2022 Act, which comes into force in spring 2023. So we can't yet use this, but this is one of the most talked about changes in the legislation, which, as you can see, changes the requirement for qualified surveyor and uses instead the description of designated advisor. I'll come on to what that means in a second. The second point, paragraph B, which is the requirement to advertise the disposal, has been removed. Although the guidance does still say that if the surveyor recommends that it's advertised, obviously the charity is best to go ahead and do that, but there's no longer a statutory requirement to advertise the disposal. And paragraph C, there, the third part of that requirement is just changing the definition of surveyor to advisor. So that the key change with that designated advisor is that rather than it now just being a fellow or professional associate of RICS, you can also take advice from a member of the National Association of Estate Agents or the Central Association of Agricultural Valuers. So it widens the pool really for charities to take advice from. They might already have a surveyor that they've been using, if you think in the context of agricultural land that may be held for a charity's benefit. If they know and trust an agricultural surveyor that they're familiar with, they should now be able to take advice from them rather than having to shop around and seek advice from somebody. A sort of cold call process. It can be quite intimidating, particularly for small charities, to have to do that. We do have quite a wide network ourselves and we can make recommendations, but it always helps if you can go to somebody that you know well and trust. So hopefully that will make things slightly easier for charities. They can shop around, get suitable advice and hopefully get a cost benefit from being able to choose from a wider pool of advisors. So just to summarise then briefly, so the three key changes that we've talked about today are the greater flexibility that should come into play for charities disposing of land where they only have a partial interest. Makes things easier for all of the parties involved. If a charity only has a partial interest, they no longer need to go through the process of obtaining consent, although the guidance does suggest that they take appropriate advice if they still think it's necessary to do so. The employee loosening of restriction for connected parties should help charities who are granting short-term residential tenancies to employees to use as their home. And the professional advisor restriction for qualified surveyors' advice is now a wider pool of designated advisors, and you no longer need to advertise that disposal unless recommended by your advisor to do so. So hopefully all of those will make things a little bit easier for the charities. There's other clarifications in the new legislation. There are various grey areas that people struggled with, which should now hopefully be more straightforward and easy for people to follow. I think we've got to the end of our update there. So just going to bring Louisa back so we can talk about some of the questions we've had. We've had a few in, and thank you very much for those. As Louisa mentioned at the beginning, we're not going to be able to cover all of them, but we've picked out a few key ones that are commonly asked questions that we'll just quickly run through. So one of them in particular is, with the new regime for the update to the qualifying surveyor's advice, and now you can take that from a designated advisor, we get asked quite a lot, can an employee of the charity give that advice? And the answer is yes, as long as they have the requisite skills and experience, are a member of RICS or an agricultural advisor or a member of the estate agents. But you should give thought to whether it's appropriate for that person to give that advice. The charity needs to be able to rely on that advice and have a fallback if that advice is given incorrectly. So you always want to think about your indemnity insurance. If that employee is giving advice, are they doing it in a professional capacity? Can you rely on their firm or their company's indemnity insurance for that advice that they're given if, heaven forbid, something goes horribly wrong and you need to try and bring a claim in order to protect the charity's assets? If the trustee is or employee is only giving advice for the charity and not in their professional capacity, and so not relying on their professional indemnity insurance, the charity should think about arranging separate insurance to cover that particular piece of advice, because again, it's always best to have something to fall back on if the worst happens and you do need to bring a claim for inaccurate advice. And I think Louise is just going to talk briefly, just to widen on that question about the estate agent's question, which we also get quite often. Can the selling agent give that advice as well?
Yeah, that's a really common one. And my view is that the selling agent should not do the report. And the reason is that the wording in the Act is that the surveyor must be acting exclusively for the charity. Now, perhaps they're not necessarily influenced by this directly, but the selling agents are usually working on the basis of a commission from the sale of the land, not always. And so I would question whether they are able to give that, to stand back and give that balanced view of whether that particular transaction is in the best interests of the charity. If it really has to be the same firm as the selling agent, then the trustee should really be asking for a different surveyor in that firm to do the report. And then at least that gives some impartiality. But it's a grey area and it really depends on the circumstances. So I hope that helps. We've also had a question in the chat, which I can answer quickly, about accepted charities. We don't come across those all that often, but accepted charities are accepted from registration with the Charity Commission and not accepted from the Part 7 provisions. So I hope that answers your question. I think that's probably all we've got time for. But as I say, do send us any other questions. Feel free to get in touch with us direct.
And just a reminder that our next webinar is coming up on the 13th of September, which is managing board disputes. So very useful for trustees and charity governance update. Perfect. So thanks everybody. Again, please do fill in the feedback form and get in touch if you want to follow up on any further questions.